evidence was laid before the committee that in 2011 there was no registration of voters going on. My lords, if you look at the evidence of the first petitioner before the committee, he said there could have been a typographical error. My lords, in her own evidence, she indicated that it could have been a typographical error. And that benefit of doubt was given. And even if we were to assume that this card was allegedly issued in 2012, when the registration of voters was going on, there is evidence on record that if you put digit 12 in this, instead of 11, you put 12, the information that will come out is for a man, a Geoffrey Moirori. That is evidence on record captured for the committee.
The jurisprudence that we establish in these proceedings is very important jurisprudence. Whether we are going to be like in the colonial days where carrying a pass was more important than declaring your name and where you come from. You are no person unless you have a pass. But we have a free country where every Kenyan who is born in this country has rights which cannot be curtailed merely by reason of the fact that certain documents have not been produced. And you know, the fact which I cannot reconcile with is that the Electoral Commission itself is already in the mode of defending itself. It's saying, we're investigating. Even as we sit here, they don't know how that set of circumstances came around. This is the commission that is established to make sure that the government of the day that is formed under the Constitution is the government of the people. And they are telling us that all these things that we're talking about are still under investigation. Not under them. They are reported to the CID and the Anti-Corruption Commission. In their own words, one of the witnesses was saying that the booklet was lost. Those circumstances have not been investigated fully. And if you look at what Section 11 is saying in the Elections Act, is that unless there's really proof, final proof, through a conviction in a criminal court, you should not deny a Kenyan a right to participate either as a candidate or as a voter in the Republic of Kenya. So, my lords, that's what I wish to say.
The case against Wiper, in my humble submission, is unassailable, with all due respect. And prayers such as a declaration that the proceedings were unconstitutional cannot be challenged. Prayers that the second respondent acted out of jurisdiction cannot be challenged. You see, my lord, the tribunal was not exercising an appellate jurisdiction. But even if it was, because that is why they accepted evidence from Viva Voce. You don't accept Viva Voce evidence on an appellate jurisdiction. So in their minds, it was clear that they were exercising an inherent original jurisdiction. But even if they were, then we have shown how that appellate jurisdiction was not correctly applied.
When the submission is made by the respondents or on behalf of the respondents that rubbishes the acknowledgement slip, it is against all Kenyans who hold that document. It means today I cannot be sure whether I am registered as a voter except if I exercise the right to vote. It is a prerogative to exercise the right to vote. The right to be registered as a voter does not crystallize only after voting.
So we will issue the judgment on Friday, 19th July, 10:30 in the morning.
Most obliged.
Thank you.
fact, I think it opens the submission concerns.
Now,
I finish my time.